Sometimes the unimaginable happens and lives are forever altered. If such a situation occurs, you want to make sure that you're compensated up to the full extent of what the law allows. With me today to discuss a recent multi-million-dollar settlement they secured for a client who lost her young child in a pedestrian accident are Spar and Bernstein partners and personal injury attorneys, Moshe, Borukh, and David Levy. Hey guys, what's up? How you guys doing?
Nice to be here, Jonathan. It's nice to see you.
It's great to see you too. So let's just talk about what exactly happened.
Sure. She was walking with her child at an intersection in Queens. She had the green light. She had the pedestrian crosswalk lines allowing her to cross the street. As she was approaching the intersection, she looked both ways, made sure there were no vehicles approaching her. She crossed the street. As she entered the middle of the intersection, a commercial vehicle struck the stroller that she was carrying with her child in it. After the accident, it was determined that the child had very serious damage to the brain. And without getting into, much more detail about what the actual injuries look like, as you can imagine, they were pretty severe. Luckily, the police were right next to, there were unmarked vehicles around the neighborhood who actually saw an accident happen. They got out of the car, they ran over to perform CPR to determine the extent of the injuries of the child. They rushed the child to the emergency room, and only at the hospital where they tried to revive the child, they determined that they couldn't revive the child and pronounced the child dead.
Oh, man. That's horrible. Did the driver stop after the accident?
So the driver did stop. I think he could have not stopped because the vehicle was touching the stroller and the child. So I don't think it would have been feasible for him to leave the scene. The police came over to him to determine whether he was under the influence of alcohol. At the scene, they performed a sobriety test. Luckily for him, it was negative. However, when they brought him in and they processed him for failing to yield to a pedestrian causing physical injury, they performed what's called a Draeger test. And a Draeger test also determines whether you have any alcohol or drugs in your system. Mm-hmm. They then determined that he tested positive for cocaine and marijuana. So that was a big issue in this case in favor of our client.
Right. And I believe you said that the mother was crossing the street with the light in her favor, right?
Yes.
Okay, so
it's the hand signal that flashes, whether it's white or whether right. So she had that clear. It was undisputed, because if she had the green light, that would mean that the person who's making the left-hand turn also has the green light. However, the law says, and it's specifically Vehicle and Traffic Law 1146, it states you must yield to a pedestrian. And failure to yield to a pedestrian is a violation.
Were there any criminal charges filed against the driver?
So unfortunately, because the driver passed all of the field sobriety tests, and these are the, walk in a straight line, touch your nose, all those standard subjective testing, the driver was deemed to pass those tests. The only test that he failed was, as Moshe mentioned, the Draeger test, which shows traces of marijuana and traces of cocaine. He could have had marijuana and cocaine in his system 2 days ago, the night before, the morning of. They determined that while the traces were positive, the police determined that he wasn't actively under the influence while driving. I don't agree with that. Moshe didn't agree with that. But that's a criminal aspect. That's a decision that prosecution made not to pursue criminal charges against him. And that's out of our control. It was a state judgment. And as a result, the state determined that it wasn't a case that they could prove beyond a reasonable doubt, which is a higher criminal standard, that they'd be successful against the driver. And as a result, the driver wasn't prosecuted, which on our end, on the civil end, put a lot more pressure and a lot more motivation for us to ensure that even though criminally he wasn't going to be held liable, we were going to do everything in our power to make sure civilly he was going to be under the full force and effect of the civil laws of New York.
Yeah, here's the good news, though. Although he wasn't criminally convicted of any crimes and all charges were dropped against him, he was found to be in violation of the Vehicle and Traffic Law 1146, which says you must yield to a pedestrian. So what we did, because we're such great lawyers, and I don't say that in a joking manner, what we did was we took that violation in an administrative court pursuant to the DMV type hearings. We took that decision from an administrative law judge. We brought it into our civil action in Supreme Court. It's called summary judgment on the issue of liability. We convinced the judge that this administrative hearing basically sought out all questions of issues of whether this person violated the law in not failing to yield to a pedestrian and whether this violation was a proximate cause of the accident. And the judge agreed with us. And what that meant was, if this were to go to trial, we don't have to prove that he was negligent as a matter of law.
Gotcha.
Right, that issue was already determined by the judge. So all we had to determine after we did what we did was what amount of damages, if any, the mother and unfortunately the deceased child were entitled to.
Well, who do you actually sue in this case, or a case like this?
So he was an employee and he was working for a company. And under the law, when you're working for somebody, there's a concept known as vicarious liability. All right, there's a lot of other fancy names for it, but basically, as an employee, you are an agent for your employer. And as a result, your employer is responsible for all of the actions committed by your employees during and in further of the scope of their employment. So since he was behind the wheel on work during his work duties, during regular working hours, when the accident happened, we were able to sue him individually, and we were able to sue his company that he was a representative of.
Oh, okay. So what were the injuries that you did sue for?
Let me just clarify. There were two separate cases, all right? We have the infant decedent who passed away shortly after the accident. That was being represented, again, by the mother. Having an estate set up, you have to set up the estate vis-a-vis surrogate's court. You have to set up an administrator or administratrix to act on behalf of the decedent. We did that for the decedent infant. Now, we also have, and this is where it gets tricky, you have the emotional distress claim from the mother. However, in most cases, let's say the mother wasn't there and it was just a babysitter and this happened, the mother would not have any cause of action in any court. Why? Because the law doesn't allow you to. The reason why she was fortunate enough to have access to a cause of action in this case is because she was there. It's something called the zone of danger. If you're a very close relative of the person who was injured, if you're within the zone of danger, and the case law, goes into that and what that means, if you are in the zone of danger, you can recover for emotional distress as a result of a catastrophic and tragic accident such as this. So we had the infant decedent's case and the mother's emotional distress claim all in one action.
One thing to that, the emotional distress claim was very important because the infant was 21 months old at the time of the accident, and the impact occurred to the skull of the child. And the defense attorneys, although obviously this is not something we condone, their argument was, using New York law, which we do not agree with, but that is the law, an individual who sustains life-altering traumatic injuries, there's a question of how much pain and suffering an individual experiences if they are determined to die after a very short period of time after the traumatic event. So in our case, all testimony showed that the child who suffered the skull fracture sustained pain and suffering anywhere from 0 seconds to up to 45 minutes when she was pronounced deceased at the hospital. Was it 5 minutes? Was it 30 minutes? Was it 45 minutes? We'll never know. But the defense attorneys had a case to make that there was potentially no pain and suffering. And unfortunately, the laws of New York would give them the opportunity to limit the amount of damages that our client can recover because there's no pain and suffering. There's just wrongful death in that case. And that's very, very unfortunate for plaintiffs, which is why you need, competent attorneys who were able to bring all these other claims that we brought, such as the zone of danger that Moshe was talking about, which is basically a claim for emotional distress or the trauma of witnessing a child pass away in front of your eyes.
Now, this is where experts come in, right? How do you determine whether there was pain and suffering of the child? That's obviously something that's going to be litigated, because if there's more pain and suffering, then your damages, your pain and suffering award, obviously logic dictates, should be greater, higher. So what did we do? We hired an expert, namely a pathologist, to determine, you look at the autopsy, you look at the photos, you look at the police report, you look at the file, the NYPD file, you look at the deposition transcripts. They look at these things and they will come to a conclusion based on medical evidence, based on everything in the record, and they will come to a conclusion as to whether or not there was pain and suffering. Our pathologist determined that there was pain and suffering. Why? We had our client testify that there was signs of life after the impact. And so that's what we did, because we can't determine. We're not doctors, we're lawyers. So it's our job to get competent medical evidence vis-a-vis experts, and in this case, a pathologist, to determine whether there was pain and suffering.
Was this case actually going to go to trial?
So we were preparing for trial. I mean, this is a type of case where you don't walk away unless you know that you're making the client whole. And again, in this particular case, no amount of money will ever make a client whole. So it's not something that we can present to our client and say, look, this number will make you whole. I mean, you can't do that. However, you have to keep in mind that no matter what you do, if you go to trial and you get $100 million verdict, there are courts out there, specifically the Appellate Division, the Court of Appeals, that will take that verdict and they'll knock it right back down to what we call the sustainable value of a case. So the courts will, the courts are out there putting values, maximum values and minimum values of cases. And we know what those values are, the perimeters. So it's our job to make sure the client understands that although she suffered a loss that will never be recovered again, that she has to be within the reasonable perimeters of settlement value.
In this firm, we do a lot of trial research. We focus grouped what the loss of a child is worth in front of a jury. We were very confident that we were going to get in the 50, 60, $70 million range. That's how confident we're, number one, in our skills, number two, in the type of case that this was. Yeah. However, as Moshe said, what's the goal here? Is the goal here to get a verdict that where we can show we got 60 million when they end up appealing it for the next 3 to 4 years and the client walks away with whatever the appellate judge determines? Or do we want to reach a number at a pre-trial that is obviously in the millions of dollars that the client will accept and that will be sustained by the judge? The client chose to go the latter route. The client chose to accept a settlement before trial.
See, thank you for that, because I actually never knew that.
A lot of people don't know this. The first thing you see in these personal injury commercials is 60 million verdict, 20 million verdict. But what a lot of people don't understand is that verdict is just a verdict. It just means that the jury has presented a number in relation to what evidence they've seen in a courtroom. But then it gets much more complicated. The judges get involved, appellate judges get involved. So things get very, very tricky once you get those types of verdicts. That's why you have to make sure that if you're offered something that within the bounds of what's sustainable, you have a duty, I believe, to your client to let them know that this is where you stop.
So I'm sure a lot of people would want to know, how much did the case settle for?
So we got $3 million for the mother for her emotional distress, and the estate of the infant received $400,000. Now, let me quickly decipher why those numbers are like that. In New York, and again, Levy and I don't agree with this law, but in New York, they don't value a death in and of itself as valuable. Okay, I think it's aberrant. I think it's disgusting, but I'm not a legislator, so I have no control over that. Right. So what that means is if you get injured and you have no economic value, you have no wages to show that your life is worth something, you don't recover anything unless you have pain and suffering, which is why the defense attorney was adamant about telling the judge there was no pain and suffering, and therefore the value of the estate is zero. Okay. Wow. That's the issue. So the mother, however, I mean, you can imagine what the pain and suffering is like. That's something she's going to have to endure for the rest of her life. What's the value of that? That's something that would have been presented to a jury. But in this particular case, what we did also, notwithstanding the expert of the pathologist, we hired an economist. Why did we hire an economist? Well, we wanted to show the judge that this infant would have went to college. Yes. If this infant would have went to college, the economist has a special formula he uses to show you what the value of a college student's BA degree, for example, is. And he determined, the expert, that over the lifetime, this infant would have made approximately $7 million and change. So what we argued was, look, judge, no, this is not somebody who doesn't have a value. This infant would have went to school because the mother testified that she would have made sure that they went to school, and they would have had a value of $7 million plus. So that's what we did in relation to the economic value. And we call that the pecuniary value. There's a difference. Pecuniary means economic value, monetary value. Non-pecuniary means just like, emotional distress. And that's how you decide for the two cases.
And the emotional distress claim, we ended up settling for the $3 million for a total global settlement of $3.4 million. And just one more point I'd like to add here. We see these types of cases every day. Some are a little bit cleaner, some are very messy, some are very, very difficult to even talk about. This is one of those cases. We can't even, begin to try to comprehend, and I don't wish this upon anyone, of what this mother was going through for experiencing and witnessing such a tragedy. All we can do is ensure that our clients are given full reimbursement to every penny they are owed under the law. And I believe that's what we accomplished. But just one more thing. From the moment we received this case until the moment we settled it, it was a period of 15 to 18 months. That's a year and a half of litigation for us to go from zero to $3.4 million. And me and Moshe are very, very proud of that, because you hear about cases dragging on for 4 years, 5 years, 6 years or more. And here at Spar Bernstein, we don't play games. When your case is here, we're going to do everything in our power to get that case from A to Z as quickly as possible and ensure that people are compensated for their injuries and for their losses as quickly as possible.
Man, that's amazing. First of all, I want to thank you guys for joining us. You know, it was a very, very tough case to talk about. And it's also good to know that if someone had experienced something traumatic and life-altering like this, you and the team at Spar Bernstein are here to ensure that they get the highest compensation they're entitled to under the law, just like you said. So I really appreciate you guys for joining me. All right.
Thank you for having us.
Absolutely. All right, everybody, to get in touch with Moshe, David, or any of the other talented attorneys here at Spar and Bernstein, make sure you call 1-800-529-5465.
Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.